Okay, we're going back on the record. State of Ohio versus Erica Stefanko. It is 2:04 p.m. And neither party has anything further to say.
No, Judge. Thank
No,
you.
Your Honor, not on behalf of the defense.
Okay. Mrs. Stefanko, you were convicted of count 1 and count 2, which were originally count 15 and count 17, aggravated murder and murder. The State of Ohio and attorneys Laybourne, Kelly, and Kranek have agreed for a merger of those counts for the purpose of sentencing. The state is moving forward on aggravated murder. The indictment reads that you purposely and with prior calculation and design caused the death of Ashley Biggs. The law requires me to listen to the statements of counsel, listen to relevant evidence, consider the sentencing factors, the seriousness factors, and the recidivism factors before the court. The court has analyzed those seriousness factors and the recidivism factors. The sentencing court, pursuant to law in the Ohio Revised Code, shall consider all of the following that apply regarding the offender, the offense, or the victim, and any other relevant factors as indicating that the offender's conduct is more serious than conduct normally constituting the offense. The physical or mental injury suffered by the victim of the offense due to the conduct of the offender was, I have to consider these, whether that was exacerbated because of the physical or mental condition of the age of the victim, whether the victim of the offense suffered serious physical, psychological, or economic harm as a result of the offense, whether the offender held a public office or position of trust in the community, whether the offender's occupation, elected office, or profession obliged the offender to prevent the offense, whether the offender's professional reputation or occupation, elected office, or profession was used to facilitate the offense. I have to consider the offender's relationship with the victim and whether that facilitated the offense, whether the offender committed the offense for hire, whether in committing the offense, the offender was motivated by prejudice. The sentencing court shall also consider all the following that apply regarding the offender, the offense, or the victim, and any other relevant factors as indicating that the offender's conduct is less serious than conduct normally constituting the offense. If the victim induced or facilitated the offense, whether in committing the offense, the offender acted under strong provocation, whether in committing the offense, the defendant did not cause or expect to cause physical harm to any person or property, and whether there are substantial grounds to mitigate the offender's conduct, although the grounds are not enough to constitute a defense. The sentencing court also must consider all the following that apply regarding the offender and any other relevant factors as factors indicating that the offender is likely to commit future crimes, whether at the time of committing the offense, the offender was under release from confinement, whether the offender previously was adjudicated a delinquent child, whether the offender has not been or had not been rehabilitated to a satisfactory degree after previously being adjudicated a delinquent child, whether the offender has demonstrated a pattern of drug or alcohol abuse related to the offense, and if the offender shows no genuine remorse for the offense. The sentencing court also shall consider all the following that apply regarding the offender and any other relevant factors as indicating that the offender is not likely to commit future crimes, whether prior to committing the offense, the offender had not been adjudicated a delinquent child, whether prior to committing the offense, the offender had not been convicted of or pled guilty to a criminal offense, whether prior to committing the offense, the offender had led a law-abiding life for a significant number of years, whether the offense was committed under circumstances not likely to reoccur, and again, whether the offender shows genuine remorse for the offense. With this, Mrs. Stefanko, based upon the facts and circumstances, consideration of the relevant sentencing factors, applying the minimum sanction I've determined will protect the public and punish you without imposing an unnecessary burden on state or local resources, analyzing all the factors I'm required to analyze, including the seriousness factors, the recidivism factors, and all other factors before the court, including the following: the testimony of all the witnesses, the testimony of your co-defendant, the testimony of the victim's daughter, and your sworn testimony. Also taking into account the fact that you took the life of a young working woman who was trying to support her only child, the fact you took the life of a young Army veteran who served our country and put others before herself, taking into account that you lured this young Army veteran mother into a dark parking lot late at night while in a car with 4 young children. And this is the most egregious part. That included the victim's own daughter. Also taking into account the secondary trauma that you've caused for individuals in the community, for jurors, for court staff, and everyone else who's had to review the pictures, the testimony, and everything that happened that night. Could you please stand, Mrs. Stefanko? The court is sentencing you to a term of life in prison without the possibility of parole. Please maintain your decorum or you'll be taken out of the court. Understood? Thank you. Again, the court is sentencing you to a term of life in prison without the possibility of parole until after serving 30 full years of imprisonment. As part of your sentence, you must obey all laws, refrain from any offensive conduct, follow all the rules of the department. You are not allowed to use drugs and alcohol, and you may be tested for that. You must follow all the rules of the institution. You are legally entitled to jail time credit. This will be calculated and included in the final entry. I have analyzed your present and future ability to pay costs and fees. Considering the life sentence imposed, I will waive those costs and fees. I am not imposing a fine, and I believe the state has not requested any restitution. Correct, Attorney LaPrenzi?
That's correct, Judge.
Okay. I am now going to review your requirement to register as a violent offender. I have to read you this entire form. Erica Stefanko, you have been convicted of a qualifying violent offender offense as defined in Ohio Revised Code Section 2903.41. You are, because you are sentenced to a prison term, you must enroll in the county, in the database personally with the sheriff of the county in which you reside 10 days after your release from jail. If you are an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either 1, residing in or occupying a dwelling in Ohio for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide the sheriff certain information, including your full name and any alias you use, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle and a description of each vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and/or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially enrolled. If you change your residence during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of the above described requirements for a period of 10 years unless your sentencing court determines otherwise. Your expected residence address would be Wayne County. We've included that address. Failure to enroll or to verify residence at the specified times will result in criminal prosecution. Do you acknowledge that these above requirements have been explained to you?
Yes, sir.
Okay. And do you understand that those requirements are in accordance with Ohio Revised Code Chapter Sections 2903.41 through 2903.44?
Yes, sir.
Counsel, I believe that the defendant has already signed the form.
That's correct.
At this time, Mrs. Stefanko, I'm going to review your appellate rights. Do you understand you have the right to appeal this matter within 30 days after the filing of the court's sentencing entry?
Yes.
Do you understand that if you're unable to pay for the cost of a transcript, the record, and all relevant documents required for the appeal, that they will be provided to you at no cost?
Yes.
Do you understand if you're unable to pay for an appeal, you are entitled to have a notice of appeal filed without the payment of a filing fee?
Yes.
Do you understand if you're unable to afford counsel for an appeal, counsel will be appointed for you without cost?
Yes.
Can you afford a lawyer, or do you want the court to appoint you one for the purpose of appeal?
I would request that the court appoint one.
Okay, the court will handle that, and that attorney will be included in the judgment entry. Is there anything further from the state?
No, thank you, Judge.
And anything for the Attorney Laybourne, Killy, or Kranek?
No, Your Honor, thank you.
Okay, I would like to thank everyone, Detective Hitchings, the attorneys, and all of our deputies and our court staff. Thank you.
Thanks, Judge.